Good morning, sir.
Good morning.
Are you Traylon Martin?
Yes, ma'am.
And Mr. Martin, in cause number 25 DCCR 0270, you're charged with the third-degree felony offense of obstruction or retaliation from January 29th of 2025. What that means...
Oh, this one kicks off like a morning prayer, but not to God, to the justice system. Good morning, Tran Martin. Yes, ma'am. Boom. Before he even finishes his greeting, he gets hit with a third-degree felony. Obstruction or retaliation. Casually dropped like a Monday morning coffee order. 2 to 10 years, just like that, and you can already feel it. It's about to get messy. Let's dive into...
So I watched the video, how the case started, and I was the one that was set up with it.
So that's what a jury's for. If you don't think you're guilty of what they're said, that then
I can't assert you if I'm already determined.
I don't need to know that. That's what a jury's for.
Yes.
Either you accept the plea agreement because you're guilty, and if you watch the information with your attorney, then you've seen everything the state has, and they'll present, and we can let a jury decide. I just want to make sure you understand what the consequences are and what your options are. Do you understand all of that?
Yes, ma'am.
So...
And just for the record, I've explained this to him. I've shown him several different videos. Some of them are more relevant than others, and he indicates some things that there may be other videos out there that I don't know about. They're not.
Here we go. Tan tries to plead his case with some bootleg YouTube analysis. I watched the video. I was set up. Like, bro, this isn't CSI, Inmate Edition. And the judge. Yeah, she's not here for plot twists. She claps back with the cold steel of reality. That's what a jury's for. You don't get to rewrite the script while holding the remote. That it's simple, either take the deal or roll the dice at trial. No in between. No Netflix edits.
See any in the file from Ms. Volpino, anything else, Your Honor?
Okay.
I know she made the offer. I know that he had got a reduction on the same charge a year ago, so I don't see any reason the offer would change. And I did ask for probation this morning. I did not change Ms. Volpino's offer.
Okay. So, Mr. Martin, if you don't want to accept that offer and you want it to plead not guilty, I need you to sign the plea bargain rejection so that I know that you and I have had this conversation.
Yes, ma'am. I just want to ask, I've been trying to get a job and work to see if I can, just see if it'll help me out with my time as a trustee.
Okay. None of that matters right now, okay? Because here's what we're not going to do. We're not going to put your case on the trial docket so that you think you can get some time under your belt, and then you're going to plead guilty later. Because after today, I won't accept this plea agreement. We don't put cases on the trial docket just to buy some time. Either you did it or you didn't do it. And if you didn't do it, then you can sign that and we'll get a jury to decide. But I don't want you to think you're going to come back in here later and say, oh, I want to...
This dude really thought he could game the system like it's a punch card. Can I work as a trustee to get time off? Bro, you think this is a frequent flyer program? The judge shuts it down like a brick wall. We're not clogging the trial docket just so you can stall. You either did it or you didn't. No board games, no bonus rounds. This isn't strategy, it's straight up accountability.
All right.
Am I eligible for parole?
I don't know when you're eligible for parole. I don't know how much time you have.
I never had to do this. That's why I'm asking
I know, and that's why Mr. Parker's... Nobody knows when for sure you would become eligible for parole or if you would make your parole. We don't know that because that depends on other people, not us. I don't make that decision. Your attorney can't tell you that. He doesn't know. It just depends on...
I've explained to him how much time, based on what he's told me he has, and how much time I think he'll have to do before he's eligible. But again, I told him I can't guarantee that. But if you're not guilty, then don't sign. You reject.
So it sounds like Mr. Parker's explained all this to you. So either you don't want to take the deal, you are not guilty, and let's go to trial.
Now comes the Hail Mary. Am I eligible for parole? Like, bro, you haven't even been sentenced yet. The judge hits him with the cold, hard facts. That depends on people who aren't even in this room. Translation? This ain't Wheel of Fortune. There's no buzzer, no lucky spin, no lifeline. This is prison talk, and prison doesn't care if you're confused, scared, or just now realizing this is real life.
I'm gonna go ahead on the sign.
Sign what?
I'm not guilty.
You can't say you're not guilty and then sign for time. It doesn't work that way. Because what happens,
Officer?
for obstruction, it's not assault on an officer.
Obstruction, retaliation.
It's obstruction or retaliation, which is different, and there are different elements of that offense than assault on a police officer. So Mr. Parker has gone over that with you. If you want him to explain it again, what specifically that is before, but you cannot come up here and say I'm guilty of something, or I'm not guilty, but I want to take the deal. If you didn't do it, you go to trial. If you did it,
I want to go to trial.
okay, sign that for me, rejecting that plea offer then.
Okay, where?
Look, sir, pay attention, sign that.
Okay, where the
Right there, just defendant right there.
Okay. I got a hospital bill and I got evidence in the free world.
So real quick, hold on before you go back. Mr. Parker has been appointed to represent you. With your permission, he handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you? All right, so I'm going to appoint a new attorney today. They'll be out to see you very soon. Huh?
Can I pick one or y'all?
No, you're going to get whoever's next on our list. If you have whoever's next on the list.
You can hire whoever you want.
You can hire, if you have the funds to hire someone or your family wants to hire someone, they can do that. Otherwise, I'm appointing someone today so they can start getting ready, okay?
Yes, ma'am.
All right.
This man walks into court and drops one of the wildest contradictions ever. I want a trial, but also, can I just take the deal? Sir, what? This isn't a legal buffet. You don't get to mix and match rights like lunch specials. Then he hits the judge with, "Can I pick my court-appointed attorney?" Like he's ordering from Uber Eats. The judge shuts it down fast. You get who's assigned. This isn't DoorDash, it's due process. Welcome to the real world.
The offense of theft of property with previous convictions from November 21st of 2022. The indictment alleges you were previously convicted of theft September 17th, 2010 in two different cases. And then again, October 26th of 2015, and then September 21st of 2021 in three cases on that date. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are all those prior offenses and convictions true?
Yes, ma'am.
And then finally, in cause number 24 DCCR 1925, you're also charged with the state jail felony offense of theft of property with previous convictions. This is from June 13th of 2024. It alleges those same prior convictions of theft. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with.
Yes, ma'am.
In each of those four cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And it's my understanding you have no agreement in your case in any of these four cases, and so you're just pleading open to me. Is that correct?
Yes, ma'am.
I want to make sure you understand your cases are set for trial to begin with jury selection next week. You have an absolute right to have a jury come in and decide if you're guilty or not, and then to decide what the punishment is if they find you guilty. If we go forward this way, you're leaving that up to me, and is that what you want to do?
Meanwhile, same courtroom, whole different energy. Another defendant steps up, calmly confesses to multiple theft charges. No drama. No fake legal jargon. No, I do not consent. Just straight up ownership. And guess what? The court actually listens. No yelling. No confusion. Just structure, patience, and process. This is what real accountability looks like. Not TikTok law school. Just a guilty plea from someone who knows they're guilty. Imagine that.
Result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number 1 in each of those cases.
No objection.
It's admitted in each of those cases. Is there any evidence that Ms. Rideau is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty and true in each of these cases freely and voluntarily. find that you're mentally competent and you understand the nature and the consequences of your plea in each case, I'm going to find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your cases, and then we will come back at a later date for sentencing. And then I will number the tampering case for trial next week. Obviously, it's fairly new compared to some of the other ones, but it looks like a lot of them are getting taken care of this morning, so you never know. You guys will know today after docket what the trial order is.
One final thing, if I may, on the tampering, Judge. It's filed as a third degree, but I filed a repeat offender notice seeking to enhance it to a second degree, given the defendant's previous robbery conviction. So I just want to make sure that all of that's.
Why did you put the tampering on me when you put the death on me?
Look, we're not. This isn't a conversation. It's
Confused. I'm sorry, yes, ma'am.
It doesn't matter, and they didn't put anything on you.
I mean, that's what I'm saying.
Okay, listen.
I don't understand how is it tampering. I mean,
That's what juries are for. If you don't, Mr. Wilkerson has gone over it, I'm sure, with you. He has his position legally. You know what the options and what the consequences are in that case. In that case, if you go to trial and you're found guilty, and there is a prior robbery conviction, it's important that you understand that the range of punishment then becomes that of a second degree felony, which is between 2 years and up to 20 years. Do you understand?
yes, ma'am.
Okay. And so I will number that case for trial for next week. All right? And you go back with the bailiff.
Thank you, Judge.
Thank you. I'll let y'all know as soon as docket's done what the trial order is.
Thank you, Girl.
Yes, sir.
Is your courtroom contradiction on full display. One guy stalling, playing clueless, stretching time like it's elastic. The other walks in, owns up, faces the music without flinching. The justice system isn't flawless, but the contrast? That's real, raw drama. So next time someone says, "I'm just trying to figure it out," ask yourself, are they chasing justice or just dodging consequences? You decide. Now smash that subscribe button before the gavel drops.